Now, it's common nature that when we're ruling on a dispute or we're trying to mediate an argument between friends, we want to hear both sides of the story. And that's why it's so difficult for criminal defense lawyers to convince jurors that their client not testifying isn't necessarily proof positive that they're guilty of anything or hiding something. That's what we're talking about this week's video. Happy Friday, everybody. Hope you're having a great week and gearing up for another good weekend. Like I said in the intro, this week we're talking about defendant testimony. So defendants testifying in their own defense at their criminal trial. Something that most people will tell you is exceedingly rare. However, when I'm trying cases in front of a jury, one of my most difficult hurdles to overcome is convincing that jury that if my client doesn't testify, it doesn't necessarily mean that he or she is hiding something or guilty. We as humans are kind of predisposed to believe that. We think that if I were on trial, I would absolutely want to get on that stand and sing from the rooftops that I'm innocent, I didn't do this, and I would want to tell my story. We're also predisposed to want to hear both sides of a story. If somebody gets up and accuses somebody else of committing a crime, we want to hear from the accused. Well, what do you say? Tell me why I shouldn't believe this person, right? And so it's difficult for a defense lawyer to overcome those things that are really so hardwired into our psyche, into the way that we see things, the way that we resolve conflicts. And that's something that, as defense lawyers, we have to be very mindful of and spend a lot of time trying to plan for. So, what are some reasons why a defendant may not testify? Well, I'll tell you that there are a ton. There's a bunch of reasons why, in any specific case, testifying would be a bad idea for the client. And a lot of them don't have anything to do with whether or not they're guilty. So, let's go over a couple. First, and this one is incredibly common, the number one fear among the American public, if you survey people on what's your biggest fear, one of the consistently top three, but typically it's the number one fear, is the fear of public speaking. The fear of getting up in front of a crowd of people that you don't know and giving a speech about a topic. Even if it's a topic that you're incredibly comfortable with, that you're an expert in, the act of doing that causes some people intense anxiety. Now take that anxiety and ratchet it up tenfold, because literally your life depends on the outcome of this speech, right? You can see how that stress, that anxiety would just physically be too much for some people to bear. Not only would some people just physically not be able to do it, but they wouldn't come across as effective. They would come across as incredibly nervous. They would stutter, they would stammer, they would sweat, they would trip over and fumble their words, not because they're lying or hiding something, but because they're incredibly stressed and nervous and anxious. But by doing that, they're going to look like they're telling something that's not true. They're giving a false account, right? Because we as humans are going to be watching that and say, oh, they can't even tell their story straight, right? They must be lying. So that's one. That's an easy one. Another one is, as a defense lawyers, a lot of times our job is to hyper focus the trial on the relevant issues, right? If you're being tried for a DWI, let's say, or a sexual assault, then we don't want the trial to become about the ex-girlfriend in college that you broke up with and she's really mad at you because you lied to her and you cheated on her, right? It has nothing to do with what you're on trial for. And yet, if you get on the stand to testify for some reason, that might become relevant. There might be a line of questioning that the prosecutor can go down that would, what we call, open the door to that otherwise irrelevant information. And so strategically, we have to make the decision, it's not worth that risk of them being able to get into this completely irrelevant thing that we don't want the jury to find out about because it has nothing to do with what we're on trial for. So that is sometimes a strategic decision. The other one that often comes up when I'm trying cases is more of a psychological balancing test. When you are presented a story, okay, and you're given, here is what happened, and then another person comes on and says, no, here is what happened, right? Then our brain is kind of wired to take those two stories and weigh them right against each other and decide, well, which one do I believe more? I think I believe this one a little bit more, so I'm going to go with them. They win, right? Well, by doing that, we have what is called shifted the burden. Remember, the burden of proof in a criminal trial is proof beyond a reasonable doubt. It's not, well, I believe them slightly more. It's not more likely than not. It's beyond a reasonable doubt. But if jurors hear two very distinct sides to a story, then their brain starts to do this subconscious thing where they try to decide, well, which one do I believe more? And whichever one we believe more, we're going to go with them. They won the case. That's shifting the burden. That's doing something to the jury that they shouldn't be doing. That's them thinking that, well, we can decide the case by deciding who we believe more. That's not the burden of proof. And so if we put the defendant up there to present their story in a linear fashion, then that's sometimes what a jury or a juror will do, and that's not what we want. So again, those are just some of the reasons. There are a ton of others that come up on a case-by-case basis on why a defendant may or may not testify, or it may not be a good idea for a defendant to testify. So keep that in mind next time you're talking about a case that's in the media or you're watching coverage of a criminal trial and they say, well, the defendant is not expected to testify. Don't automatically jump to the conclusion that, well, they must be hiding something or they must be guilty, because otherwise they would get up and they would defend themselves. It's not true. It's not how it works. And it's a very damaging and harmful conclusion to reach. And it's something that defense lawyers are constantly trying to overcome because it really puts people behind the eight ball, especially if they're innocent people that are just trying to seek justice. And now they have to overcome that on top of everything else. It's very difficult. So as always, if you have questions about this or anything else, or you just want to swing by and chat about the law, life, or whatever, come by my live stream every Sunday night. Happy to see you there. The link, as always, in the video description below. Otherwise, I look forward to seeing you all next Friday. I hope you have a great weekend, a great next week. And until I see you again, be good and stay on the right side of the bars.